course, from everyone who's taken time to be here. We thought one way of going through this could be, we've highlighted a few questions. I'm sorry, I won't ask you to crane your neck. I will read out some of the questions that we've thought, but of course, any other theme-wise, any inputs, comments, ideas that you had and that you could help us maybe strengthen some ideas or maybe say they're not workable at all, that would be helpful. Beginning, of course, with the reforms looking at the NCLT itself. So we looked at the role of registrars, an admission SOP, a mandatory pre-filing check, separate benches, increased bench strength, and also addressing the problem of IAs. Some of the questions we had were, would this result in another layer of appeal from registrar's orders? What could be if we are thinking of consultants, what could be the benchmark for determining in which case expert consultants are appointed for? And how can timelines really be enforced in the insolvency process? And can we really eliminate the role of the NCLT post-approval of resolution plan? So please then. There's no questions.
Said this by way of a brief introduction. I can say that none of the stakeholders in this present IBC ecosystem can claim to be innocent. Not the lawyers, not the bench, not the appeals process, not the procedures, not the IPs, not the COC, but just stretching things. There's a reason for it. If you look at just procedural aspects, 10 years after the IBC was promulgated, or 9 years plus after the IBC was promulgated, the NCLT is still functioning with the same bench strength as it was in June 2016. Initially envisaged for Companies Act alone, now overtaken by the IBC. And what do we do at the NCLT level? What is being done to show our disposal of company law matters is to take 252 and Section 230 matters and show that we have disposed of around 86% of the matters. The real matters in Companies Act which require judicial application of mind, such as operation and mismanagement and investigation matters and rectification of registers, they are not taking place at all. There is a matter I disposed of involving Kirloskar Ibarra in 2020, just before the lockdown came in. 6 years down the line, it's just an interpretation of the second proviso to Section 58. It is still languishing in the NCLT. Now that is the state of affairs we are talking about. So merely making changes like giving registrars powers, because that is already being taken care of by the IBC now, IBC Amendment Bill. It says it's more or less an automated process. Don't look at anything other than debt and default. What else do you want the person to look at? Now there used to be a time when the BLRC was deliberating, they did not envisage that this whole process would become judicialized in the way that it has become today. It all started with innovative. When you said that you needed to give the corporate debtor a chance. Now which system in the world, given the complexity of matters, which system in the world can give the chance to a corporate debtor, get the filing of the reply done, and then decide the matter in 14 days? And the problem again is, if at the NCLT level, I decide that, okay, I am not giving you a second chance, I proceed to admit the petition. The next thing you know, from the NCLT, you will get an order saying, what was the tearing urgency to dispose of this matter when there were previous matters pending? Now this is an open and shut case for me. This is a financial creditor's application where balance sheet acknowledgement is there. The debt is clearly reflected therein. Maybe there is a difference in the amounts, but I am not required to go into that, right? But I admit the petition today. They say, okay, you have 2023 matters pending, 2022 matters pending. What was the tearing urgency to dispose of a 2025 matter? And I'll also, in addition, probably get a vigilance inquiry against me. This is the state we are talking about. Then, when you are already overburdened, 3 years ago, or 2.5 years ago, there was a new regulation, not a regulation, it was a circular issued by the principal bench, saying that progress reports should be filed by way of an IA. Now the first question I want to ask you is, where is the regulation or the rule or the code which asks for a progress report in an IA, in a CARP? It is there in the liquidation process regulation, and that is supposed to be a quarterly report. Now here we have benches which sometimes decide to ask for a CARP progress report in 2 weeks. Some benches ask for it in a month, some three weeks, some in a quarter. And I can assure you, no member reads it. I am telling you from the benefit of experience. No member reads it. And for an application, for a progress report that is not mandated by the rules or by the regulations, by any legislation for that matter, introduced by way of a circular, you also want the RP to spend time to detail the progress report. What great progress can he achieve in 3 weeks? Now, you're all practitioners. You tell me, what progress can you report in 3 weeks' time? Now, that is one aspect of the matter. Second, again, we are talking about overburdened NCLTs. If you need a correction in an order, whether it is the bench's own mistake or your mistake, now you again have to file an IA. That is the state of affairs we are talking about today. Now, if the bench has made a mistake, which High Court in the country, or the Supreme Court for that matter, asks you to file an IA for this? When my LRA copied the company's name, there was a mistake in the order. Or the IRP's name, there was a mistake in the order. Now to correct that, which is of the bench's own doing, ultimately, because if I have signed the order, I have to take responsibility for it. It is my own doing. I get the other person to file an IA, pay 1,000 rupees on it, and then pass an order after 1.5 months.
No, first hearing will happen First hearing will happen after 1.5 months.
No, at least as long as I was on the bench, the benches that I have presided over Bombay, Calcutta, Allahabad, Cuttack, and special benches at Indore. I have ensured that within 48 hours of a petition being numbered, it is on my board. That much I have ensured. But it takes a lot out of you, because there are times when I have not had breakfast, I have not had lunch, I have been sitting in office from 9, 10:30 I am sitting in one court, I finish the court at 2:30 or 2:40, take the next court at 2:45. There is one particular day I remember where I took the court till 8:45 in the night. Now this kind of a system you cannot run. It doesn't need these small tinkerings, but at least these small tinkerings will help you. Now look at the kind of you look at the thing, and the way it's presented to Parliament is we are disposing of so many ideas. We saw the statistics just now. Now you take a look at the quality of the IAs. What is the issue that is being decided in the IAs? Then you will know what kind of work we are doing. Now, in the case of Shrey insolvency, there are 137 Section 66 applications still pending. It was already resolved in 2023. We are now in 2026. At every hearing, you have a battery of lawyers disrupting the hearing. That is what is happening. Even after the bench has said we will take it up step by step, it is the lawyers who are disrupting the hearing. They don't want it to come on board. Now this is for the practitioners. Now you look at the filing system. Like you rightly said, if you have a system where you require the petition and annexures within a limited capacity, then the quality of the scanning goes down. Now you give me whatever computer you want. Even if I blow it up, I can't read it. That is the system we have implemented. What has happened is, patch by patch, they have increased it. And they say in Parliament, they tell you e-filing is done. What is e-filing? That is for you as one of the check boxes, because e-filing has to be done. After e-filing has been done, there are benches, I can tell you, I don't want to name it. After e-filing has been done, till the time you give physical copies, a number is not allowed. This is supposed to be an automatic numbering system.
No, everywhere.
Exceptions. The benches that I was presiding in, I have not taken physical copies. Except if it is an order that has been produced, say, that has been pronounced by the Supreme Court, say a week earlier. You won't have it there in the e-filing system. You give us one copy, that would do. We will share it. But that is not the system that is being followed. And you said, read the BLRC report again. Actually, if you read it, you will have to roll back the judicialization that has taken place. Rejoinders. Where in the world do you have an insolvency rejoinder? What is this concept about? You are supposed to put your best foot forward when you make a case. You are not waiting for the corporate debtor to commit before you produce a document and surprise them. And if you don't have a document, why do I need a rejoinder just to deny everything? If you are giving a document, will I not ask you, why was this not produced at the time of filing of the petition? Now you have delayed the discovery of documents on both sides. That is what has happened. This concept of rejoinder, I put an end to as long as I was presiding in all these 4 benches. But I made this upfront, I clear upfront. On the day I sat on the bench, I told them I will not take rejoinders, except in the most exceptional case. Then, coming to the law aspects. If the insolvent, now you have 2 caps. One is the company law cap, the other is the insolvency cap. Suppose today, I am the government, I decide to carve out this IBC, and under part 2 of the IBC, I define the adjudicating authority as the National Insolvency Tribunal. Right? That can be done any day. An amendment is all that is required. How will I use the NCLT rules to fill up the gaps in the code now? Where is Rule 11 coming in? And where is Rule 11 available to the DRT? It is also an adjudicating authority under the same code in Part 3. Then comes the question of contempt jurisdiction. Where in IPC is contempt jurisdiction provided for? How do you take recourse to 424? How do you do that? That's an entirely different act, right? You're not supposed to use that act to deal with IBC petitions. The only place probably where you can do it, use the information in the IBC to good effect under Companies Act is Section 230, where it says on an application made or otherwise, use that otherwise. That otherwise is the information that is available to the bench because of some things that you have seen in an insolvency petition. Otherwise, how else will I import it? Now these changes, if you think of it, what has to be done first and foremost is to roll back the judicialization of the process, like these rejoinders, like giving opportunities to the corporate debtor. In a Section 7, if it is there in the balance sheet, if the loan documents are otherwise in order, and the balance sheet acknowledges it, what else is required? How is he going to justify it? The one case that I did find, from experience again, the one case I did find was where the financial creditor had contributed to the default by not releasing the 3rd and 4th installments which were contracted by the bank with the corporate debtor for no reason whatsoever, and still that application had to be admitted. We rejected it, it went to NCLT, NCLT said beyond debt and default don't look at anything. Because if you look at one aspect here, you will look at 10 other aspects in the future. There will be something or the other that crops up. So with this thing, what you must actually do probably is to think of ways and means of rolling back, at least as far as Companies Act is concerned, rolling back all these judicialization measures. You don't have any equity in insolvency. Now this whole purpose of using Rule 11 to justify all kinds of orders should be stopped. Rejoinders must be put an end to. CARP progress reports must be put an end to. Half the, not half, at least, okay, optimistically 1/3 of your IA strengths will go away if you do all this. But certain things I liked about your presentation, which is training for banks and people who sit on the COC. Right now, it is another extension of the bank itself, or the financial creditors themselves. All of them seek approval, come back, parrot whatever has been told to them by this one. Then this separating of the NCLT into two verticals, the IBC and the Companies Act, that will take care of the Rule 11 issue. Then it identifies the core issues very well, but the route that we have to probably think, that needs a lot of work. Then this pre-distress signal monitoring, that is something we think there's a lot of mismatch or a gap between what is spoken in seminars and conferences and before parliamentary standing committees and what we're actually seeing on the ground. Now someone has to actually bridge that gap. Until that happens, this thing will remain. Then I have a problem with the registrar. I'm in agreement with all the others. With the registrar having powers of adjudication, as the gentleman rightly put it, when there's a case, other than these two, there's only a matter of limitation to be decided. And limitation is actually a judicial function that has to be done. Then this appointment of expert consultants should be not for the NCLT but for the COC. Then there's one thing where you said post-approval judicial intervention at NCLT level. I don't find any such thing happening anywhere. Post-approval, not at the NCLT level. If there's a direction from the appellate forums, then it's a different issue. But once approved, there is no intervention. As far as my experience goes, I have not seen any intervention at that level. So that post-approval judicial intervention at NCLT level, I don't think is right. These are some of my thoughts. There's a lot more to speak, but then we are short of time. I'm sorry I've taken too much of your time.
I think it must be the lawyers clapping. I think they're responding to the angst they face every day, the fighting lawyers at least. So
it will help everyone, right? Eventually it will help everyone.
I agree. See, the presentation covers too much. I think that's the comment made by everybody. So to respond to each one of them may be difficult. But let's start with the fact that it is broken. Unless we say it loudly, it is broken many times, we'll keep looking for patchworks. And I think Mr. Rajasekhar has given his side and behind his message. See, the point is there are always individual benches, individuals who are going out of their way to make sure that they function. But that doesn't cover up for the system. I think that's what I'm saying. The reason why tribunals were started was because the judiciary is having a lot of problems and you needed some expert advice, expertise in deciding some kind of matters. I think we should start with that as to what kind of experts are being appointed. Is this what maybe the two people who are part of the BLRC should say? Have you seen the members being appointed to the NCLT? Is that the experts that you envisaged? See, it is fine to say that the BLRC said many things. It may have said many things, but it's not what's working. Okay, I mean, if I'm arguing with Aakash, I argued before an NCLT, one of the benches. The It was an appeal from an order passed, probably one of the first orders with respect to an avoidance application. The NCLT heard it about a year and a half ago. He's not passed any order. Now, what do you do to that? You won't find answers to that in the BRRC. I'm sure the BRRC was great in it. I think, so if we say listen, some of the original thought process was good, nobody is denying that. But today, there are many blows, maybe rollback judicialization, maybe the capacity issue, maybe the code is fine, the problem is in execution. But I think this, the law is fine, problem is in the execution is a common refrain. And I think we should be impatient with that kind of excuse now. So it's not working. Do you need to change the design of the NCLT or the adjudicating body, or do you need to tinker with the design of the code? The answer is, I think because I see more, maybe Aparna and Anjali should tell us more about is there a design change required and what is the kind of design change required. But all of us who practice, we can say what the problems in the functioning is. And any system which envisages 14 days but takes 8 months, 1 year, 6 months is not working. What more evidence do you need to show that it is not working? But there is also an advantage. Like 2 days ago, I was watching another matter going on before the NCLT, and the lawyers kept saying JLF, JLF. And neither of the members asked what is JLF. So that means there is some expertise. They have learned what is JLF, right? Whereas if you go to a high court and you argue JLF, they will still ask you what is JLF, right? So there is some. So that probably answers you. Going back to high court may not work. Although many lawyers will say let's go back to high court, but I think that's more out of frustration with the NCLT to go back to high court. See, so I think most of the points have been covered, but somehow we need to fix this this directory versus mandatory problem. I think the Supreme Court has said it's not mandatory, it's only directory. Then that was the first. Basically, you kicked out all timelines. But it's not. It was more out of sympathy for the judges, for the benches of the NCLT, and a realistic view of what's happening. That decision was taken in my view. I don't think it was a design to judicialize the BRRC's recommendations, but it was more to say, it's humanly impossible to meet the deadline. And Rajasekhar said, how many judges should work till 9 o'clock at night every day? It's not possible. If you have anything more than 15 or 20 matters listed before you, it's not possible to get on with life. Right? And the multiple applications, I think we've all spoken about it. But what is it? So is it that you should separate the functional issues and the design is fine, so do you need to address the functional issues alone, or is there a design problem also? One financial creditor was telling me say there are 10 max. Right? It's the JLF, since we all know what JLF is. And what if only one financial creditor is filing an application and the other 9 actually think we can make it work? NCLT doesn't have any, discretion there because there is a debt. Right? So the financial creditors are actually unhappy if, in the context of a JLF, only one banker going and filing for insolvency. And then they're all even more upset if an operational creditor goes and files for insolvency. But operational creditors only go and file for insolvency when they themselves will be facing insolvency problem. That is something financial creditors never realize. Why is an operational creditor, if 1 crore is due to him? Most operational creditors don't want to go to court. And they certainly don't want to go to NCLT because they understand the pain point. But they are forced to, because if they don't recover that 1 crore, they will probably face insolvency. And you look at the practicing lawyers, and maybe Mr. Rajasekhar also said, you look at how many of the people who file insolvency application in one matter are also facing insolvency applications. right? Or facing, arbitration. So this is it is not a, NCLT is not a standalone institution, and we keep discussing Surya, and I think, the tax tribunals are slightly more at an advantage because they are to some extent insulated from the other judicial processes, but the NCLT is not. If you're saying that the NCLT's problem can be solved on its own, you can't. I mean, you have to see the touch points with other judicial processes. So, if you're giving us so much to discuss, and I think we're already past our time, I think maybe you should ask for separate discussions on each of these points. The design problem certainly, all of us practitioners can't solve much. We can suggest what is the problem. But I want to touch on one last point. See, I don't think it matters who decides, whether IBBI or some other form of adjudicatory authority, right? But whether that should be a quasi-judicial function, the first, but to admit a company into insolvency, I don't think can be a quasi-judicial function. It cannot be a quasi-judicial function. It has to be a judicial function. Even if the parameters are so strong, there could be an exceptional case. Like take the example of 10 lenders and one lender wants to proceed with insolvency, the other 9 are saying no, we can say this without going. So that's a judicial question. So I don't know whether an IBBI-like institution can work. Maybe Pramod can comment on whether this is a quasi-judicial function. I don't think it's a quasi-judicial function. You're probably stuck with the judicial decision. But does it have to be 2 members if you have a capacity problem? Okay, I mean why? I mean we have to see that. Capacity in terms of numbers, we all know. I think it's horribly managed. When you appoint somebody that person is going to retire in whatever period. So why do you have to wait one day before he retires to announce for inviting applications for you don't. And I think 3 years ago there was this charade of members retiring every day, and there was a new president at NCLT every day or every 2 days. So this is just mismanagement, and that can't be blamed on the judiciary. I mean, it's the controlling ministry which is mismanaging it. So I don't know. I mean, we can keep talking about the problem. Are you looking to us for solutions? I mean, before we came on to this place, she reminded me that 3 years ago we were talking about NCLT, or talking about NCLT again. But we need to see. So maybe separate the design problem and the functioning problem. And so if you're looking at design of the institution and design of the code, I think maybe we should separate the two. And in both there is room for simplification. Certainly in the functioning of the NCLT there is simplification possible. But the immediate solution is to increase capacity. But I don't think it's only about capacity. Like, why should there be 30 applications, 400 applications? He also mentioned about that. Why should you constantly question the IRP, the resolution professional, on everything he does? Because Supreme Court says many times that we don't want to interfere in economic decisions, in expert decisions. So how does the NCLT suddenly become an expert to question the resolution professional or the liquidator's decision? But then the other question is, if most liquidators are chartered accountants, how do they suddenly become, in 2 weeks' time, if you're asking for a report in 2 weeks' time, how does this mostly chartered accountant or a lawyer in 2 weeks' time understand the entire business? Okay, understand where the problems are, figure out what the issues are, and then come back with it. No, it's not possible. So that's the design problem we're also looking at.
So I first completely agree with everything you're saying. So I want to say two, 3 things. One is, of course, there are problems everywhere. Okay, there's problem in the design of the law itself. There's a problem in the design of the institution. There's a problem in the design of how the institutional rules are framed. So for example, NCLT is not, IBC doesn't say NCLT, IBC says A. NCLT got created at the same time
as the IBC coming about, and hence for speed it was said NCLT will be AA. So it's a creature of Companies Act which was assigned that additional response. Even today if you go and look at NCLT rules, many of the rules are just straight transport from Companies Act. The rules, that's the Rule 11 problem that is being mentioned right.
It should forms also. Sorry. The forms also must say before the adjudicating authority, emphasizing its adjudicating authority character rather than saying before the National Company Law Tribunal. There's only one bench that follows it, and that is saving graces. It is in the National Company Law Tribunal within brackets before the within brackets it says adjudicating authority, Chandigarh bench.
So simple things like why do we need physical documents to be? Simple reason, the companies, the rules coming, NCLT rules coming from Companies Act require those to now. So I agree completely. We need to break it up into problems of the law need to be fixed, problems of the institutional design, problems of institutional incentives, problems of institutional infrastructure. Why do we have a set of judges and not more? Do we need more? Why is the filing process one way and not the other way? Why do we not accept IU records as a primary evidence of which can be used for admission? Simple, Evidence Act doesn't allow for it. Most judges are very, so the one thing we should do is to not presume that what has come about is a mistake. What has come about is often an outcome of the many things that surround it. Evidence Act does not allow for primary evidence, IU records to be primary evidence. If we read the IU report, it says exactly that. The section 7 of IBC till I think the recent amendment does not make the mandatory acceptance of IU records by NCLT as the criteria for admission. So people are looking at all sorts of documents. So all I am saying, Harish, is between problem identification, which I think is absolutely correct if the system is broken, and solutioning, the steps have to be more rigorous. Otherwise, we miss solution just for the sake of it. That is my concern.
We have a thank you everyone for taking the time. I understand it was a lot to unpack and these are multiple themes. But I just wanted to take, we've been told we have less time, we have a panel after this. So just a few minutes, maybe 2 questions sort of comments, any ideas if anyone has, please.
Does anyone have any questions?
He has a question.
So we have debated this question of resolution versus recovery a lot of times at the NCLT and Adjudicating Authority. I mean, this is also comes from the fact that every time the defense is taken, they say it's in IMOC. They say that it's probably a process of recovery, not a process of resolution. And this is also the side of the institution. When they measure the success of any institutions, can recovery be the first of the matrix where we can say that IBA is performing well or IBC is performing well? Because we get 2 yardsticks. Whenever success of IBC is spoken, we speak about recoveries. But when we talk about process as such, the recoveries are never even a question. We say, no, it's not a recovery process, there is resolution. Can there be a scheme wherein we say once for all that IBC is also for recovery and just not for resolution? I mean, this is a question I would ask.
See, why not? If the law allows you to file the insolvency petition, you should be entitled to file it, whatever your motive is. And if your motive is, you want the money, I mean, you want the money at the end of the day. If you're an operational creditor, you want the money. How do you care whether he becomes insolvent later or not? It doesn't matter to you. And that's the touch point I was mentioning earlier. The reason why operational creditors use the IBC process as a recovery tool is because the other process is broken. If you are able to get a summary judgment in actually 3 months, as a CPC wants you to do, or 6 months or 1 year, or if it's a simple money suit where you can get a award from the civil court quickly, you will go there. The reason you are coming here is it's quicker and cheaper, and there's a lot of pressure on the corporate debtor to settle, because he does not want, the corporate debtor doesn't want the reputation of somebody, a company being under insolvency. It's as simple as that. So why not? I don't see a problem with it at all. The problem, at an institutional problem, if you're looking at the country as a whole and insolvency process, then at a theoretical level there may be a problem. But at an operational level, I don't see a problem. It's a right available under law. Why not use it? What's the problem?
No, I agree with that, and I actually think it's a sort of false dichotomy that one concern is that IBC cannot be used as a recovery tool, because that is, maybe as Harish was saying, overall the idea is for resolution. But I think what was meant by that more is that IBC is supposed to be a collective process. So once an application is admitted, it's supposed to go towards resolution. That is the point where it's supposed to be a resolution tool. It's not just saying that, of course, any creditor who files an IBC application, their motive is recovery, right? And you would want them to also be able to recover. So I think that's sort of a false dichotomy when we keep saying cannot be used as a recovery tool. And that's why I think it's also a little dangerous to propose that, for example, OC should not be able to initiate, because unlike financial creditors, they actually don't have any other tools in their toolkit other than like going under the contract or arbitration or going to a civil court, right? So I do think that maybe that is not the measure of saying IBC cannot be used for recovery.
Let's look at this in this fashion. Recovery is a necessary byproduct of resolution or of liquidation. It is a necessary byproduct. You cannot have a situation where a financial creditor has filed an application, or take any creditor for that. Why make this distinction? The committee of creditors approves a resolution plan with zero recoveries for everyone, but keeps the corporate debtor afloat. Can that happen? Can that happen? It is a necessary byproduct, and it is recognized even by the government. That is why they say 3.5 lakh crores has been recovered under the IBC, and this is one of the fastest moves. It is not that it's a bad thing to recover, but your primary focus as part of the resolution plan also, what is it that the FCs do? They look at the recoveries only and then try to put the corporate debtor back on its feet. So if the recoveries are bad, but the resolution plans propose only 1 rupee for every creditor, do you think such a resolution plan will be approved? It is not going to be. So don't look at it as something bad. Where it is a problem is when this particular OC, for instance, keeps repeatedly filing applications only as a means of recovering that money that is due to him. If I admit the petition, he is not going to come forward to contribute anything to the thing. And none of the financial creditors are interested in putting the corporate debtor under CARP. I have personally seen OCs back out saying, I have already spent so much money on the application process itself. Now if you ask me to shell out, because there is no other FC, he has to sit on the COC now, and nobody else wants to join. Now he says, I will not do anything. I can't keep the company afloat. Now what do you do with it? Other than initiating proceedings against him under Section 65, what else can you do? This is the problem. There you have a problem of recovery being the primary mode. So if it is part of the resolution process, there is no problem.
We can speak later. But one thing I will say is that I think, look, it's a mechanism available. It creates certain incentives for some parties. They are using it a certain way. It's a legitimate mechanism, so no complaints. Everybody has mentioned that. But one interesting fact, and there's a bit of work that I and a colleague of mine have done on this, shows that persistently financial institutions bring very, very stressed firms to bankruptcy, whereas operational creditors will actually bring them at the earlier stages of stress. Whereas there is some possibility of resolution. FCs, the way their incentive structure is set, and that's completely outside the domain of IBC. It's through banking regulation and other such design mechanisms of other parts of the economy, actually bring cases when they are nearly unresolvable. So, to vilify the OCs is not enough. We also have to see the positive contribution they bring to the system. Is that FCs don't bring cases. OCs are the threat that forces them to bring some cases to bankruptcy in time. Otherwise, the system will go to the old ways of 6-7 years of write-off on the bank's books. That's a problem.
And OCs actually may know the financial health of the corporate data much better and earlier than the FCs.
Working capital is where it shows up first. We shouldn't forget that. Yeah.
They know they are the ones who feel the pain, so they know it very well, very quickly.
Thank you everyone, and thank you for your time, your feedback. We have upcoming panel waiting, so thank you. Thank you everyone.
Abhishek.